are aware of the order of this court and have, however, failed to comply with the directions. In view of the above, issue notice to the respondents. Steps would be taken by the petitioner within a period of 3 working days from today. List on 16th of September 2026 along with service report.
Item number 3.
My Lord, this is a revision petition under section 115 of CPC Red section 227. Regard to the impugned judgment and order dated 17/6/2026 passed by the Additional Session Judge 3 Aizawl in RFA number 4 of 2025. My Lord, the appeal RFA has been dismissed on the ground of no merits. However, my Lord, the appellate court has overlooked some of the facts and erred in their.
No, it says that the prayer portion of the memorandum of appeal has challenged the issuance of order dated 21/7 and certificate in airship certificate number AZL-42 of 67.
Yes, my Lord.
Whereas this appeal is concerned with airship certificate number 1027 of 2016.
My Lord, in that matter, there is a topography mistake from the counsel of the appellant.
In the original.
Yes, in the.
But this was in an RFA.
Yes, it was in the RFA, and it was later on noticed that there was a topography mistake in the regarding the LSC number, mentioning the LSC number on the ground mentioned on the memorandum of appeal. But the appellate court has not given the chance to rectify or
No,
amend.
did you pray before the appellate court?
Sorry, my Lord.
Did
Yes,
you
we have,
make any application before the appellate court?
It was noticed only on the hearing stage of the appeal, and then we orally asked and say that if it is required, we can submit application for such amendment. But the appellate court has not considered our submission, and it dismissed the appeal.
It is only in the prayer portion that the mistake has cropped in, or is
My
it
Lord,
throughout?
it's actually in not in the prayer section. It's actually in the ground mentioned in the memorandum of appeal, and in the prayer section it is correct. And kindly look page 33 of my petition, page 33. In the ground mentioned for the appeal, it was inadvertently mentioned airship certificate number AZL-42, which is actually the LSC number. And in the prayer section of the memorandum of appeal, it is clearly stated that airship certificate number 1027 of 2016. So it was not in the prayer section, it was only in the ground mentioned in the memorandum of appeal, and which we prayed that we can amend that portion, but the appellate court has not considered our submission. So we approach this honorable court.
But in the order, different places they have
Yes,
written
my lord.
1027, 1027. Why?
Yes, it was actually,
From where did they get the
my lord,
number?
I don't know from where did he get, but in the oral submission in the hearing stage, the respondent counsel of the appellate,
Come to page 30.
page 30. Yes.
What is it written? Page para 3.
Page 30 of
Para 3.
para 3. Yes. The instant appeal is for setting aside and cancellation of the impugned heirship certificate number 1027 of
Then-
2016.
Then you start from there only.
Yes.
You start your mistake from there only.
My My lord, heirship certificate is 1027. Heirship certificate is 1027 of 2016.
Huh.
Yes.
And
And the in the judgment and order which the appellate court have mentioned is regarding heirship certificate AZL 42 of 1967, which is actually is LSC number.
memorandum
Here also it
challenge
is
the issuance
mentioned
of
that
order dated
heirship
21.
certificate number 1027 of 2016 dated 21/7/2016 and its order passed by Civil Judge Aizawl Judicial District. The said
No,
heirship
here-
certificate declared OP respondent, which is to be the legal heir of.
Just a minute.
Yes.
As Hyderabad Lana Council, the prayer portion of the memorandum of appeal challenged the issuance of order dated 21/7/2026 and certificate in heirship certificate number AZL. Where is it? In the prayer portion?
Yes, in the prayer portion, page 35 in the memorandum of appeal.
It is not there.
It is there, my lord.
AZL 42.
Yes, my lord, it is not there in the prayer portion. That's why the appellate court has inadvertently dismissed the matter. We actually pray for 1027 of 2016 to be questioned and to look into the matter judicially. But the trial court has, in the hearing stage of the appeal, the respondent have noticed that there is some topography mistake in the ground mentioned in the memorandum of appeal, which is in
What is the
page
full form of this LSC? LSC?
42 of
No,
SSL,
what is the full form of LSC?
land settlement certificate.
Land settlement certificate.
Yes.
Okay. You are Mr.
Ram Murmu.
Mr. But Mr. Sansulula Council is paying for the petitioner full stop. The challenge in this civil division jurisdiction is to the order dated 17/6/2026 passed by the additional session judge 2 additional session judge 3 Aizawl Mizoram in RFA number 4 of 2025 arising out of heirship certificate number 1027 of 2016. Stop. The Learner Counsel for the petitioner has submitted that instead of allowing the petitioners to take appropriate steps for correction of typographical error in the prayer portion of the RFA, the learned court had dismissed the appeal on the basis of the typographical error only. Full stop. Issue notice, returnable 4 weeks. Petitioner to take steps for service of notice within a period of 5 working days from today. List again after receipt of the service of notice.
Oblige.
Item number 4.
Page 21, paragraph number 4. So no objection is filed by the respondent
And where is
despite
the-
given chance since 512. It seems that this application was filed in the month of December 2025.
No, what we are trying to ask you now is, an
Yes.
application is made.
Made.
They do
Not
not call for a report from the DTO or the other
No,
persons
no,
to
no,
ver-
no,
to
not
verify.
done, not done. So as soon as we have received the this application, we have done our investigation and we have approached the DTO, and we are having the registration certificate, Lordship, which is with me in the earlier quote. Also, I have submitted that things. This is the registered owner, Vanlal Siama.
Have you given the order dated 5/12?
512.
What is the order dated 5/12 passed on this petition?
No, no, Lordship.
You have not even given that. See, if you had
5/12.
given the order dated 5/12,
Hmm.
if you had given us the order dated 5/12, and
5/12.
if you had also thereafter made a submission that on 5/12 we did not even receive a copy of the application.
And the date when we have received the this application was on 29/1/2020.
Yes, but we will, if you had given us the order 5/12, we would have said the,
Obviously, we will approach the respective DTO and find it out that whether the applicant is the real owner or not. If that's a real owner, then we have nothing much to say. There are so many apex court rulings. But he is not the one who claimed the ownership is different from the registered owner recorded in the DTO.
your grievance is only with regard to one of the,
Yes, the other we have approached the DTO and he is the registered owner. So we have nothing much to say. But this particular vehicle is registered in another name. But the problem
do you
is,
find
Lordship, if we have filed
how did you find out that it's in the another's name? Where is it?
Lordship, it's there
In the annexures, where is it?
in the
That
annex.
this is how we come to know that it is not his vehicle.
Lordship, yes.
On what basis are you saying so?
Lordship, this I have the registration certificate. This is from the DTO Kamrut.
It is his name, owner.
It is in his name.
Then
Then this is there are two vehicles and
where
one
is the
vehicle.
other one?
The other one is Lordship, yes.
With whom?
Uh,
Who is the owner?
As per the DTO record, the owner is R. Vanal Siama.
Okay. Give us that. If you had brought these on records, you would have got a stay on the release of the custody, or at least something. Office note dated 12/8/2026 reflects 7/8/2026 reflects that the postal receipts have been returned from the post office. However, there is no noting as to whether the notice had been served upon the respondent hearing on the correct address stated to have been filed by the learned special public prosecutor. Full stop. Awaiting service of notice lists the matter again on We'll have it after a week,
Lordship,
2 weeks,
2 weeks, Your Lordship, yes.
12 week, na? 1st of September.
No problem, yes.
Hmm?
Yes, Your Lordship.
1st of September 2026.
Item number 6.
My lord, this case pertains to regularization of the service of the petitioner's contract service. And I have been informed that active steps have been taken by the respondent authority concerned. So we may wait for some time.
Steps have been taken by the respondents
Yes, my
to
lord,
comply.
for compliance.
Yes, Your Lordship.
The heard Mr. Victor R. Ralte, learned counsel appearing for the petitioner. Also heard Ms. Lalunbi, learned counsel appearing for the respondent contender number 5. It is stated at the bar that appropriate steps for compliance of the order dated 26/6/2025 passed in WPC number 69 of 2025 are being taken by the respondents. Stop. List this matter again on the 7th of September 2026, by which date the respondents shall file an affidavit stating the compliance of the order dated so and so.
Much obliged, Your Lordship.
Much obliged.
Item 7.
Yes.
My lords, if it may be passed over, my lords, the council has just,
Huh?
she's on legs in court one, I think, my lords, if it may be passed over. My lordship.
Lordship, in the last court date, this honorable court has condoned a delay of 63 days. And this is the first time the main revision petition has been listed. So, in this revision petition, Lordship, we are challenging the order dated 19/9/2025, wherein the executing court has dismissed the execution petition and make a further direction that since both, Lordship, the impugn order is on page number 2 of the, right after the index, Lordship. And the relevant portion is on para number 4. Although the decretal amount is of meager, Lordship, but however, we are challenging the legality of this executing order, court's order. Whether this is proper,
Heard Mr. Sulana counsel appearing for the petitioner. The challenge in this, no, you write it like this. The subject matter of the present civil revision petition is the order dated 19/9/2025 passed by the Civil Judge Junior Division number 5, Aizawl District, Aizawl, in execution number 97 of 2025, whereby the execution petition was dismissed. Full stop. The learned counsel for the petitioner has submitted that the learned executing court, having recorded that the judgment data number 1 and the judgment data number 2 were yet to satisfy the decree earned by the petitioner herein, the the executing court committed error when it dismissed the execution petition directing the judgment debtors to make monthly payment diligently till settlement of their respective debts. Where is that order of the order of which you had sought the execution?
Lordship,
Where is the order of which you are seeking an execution?
Lordship, this is a lock adalat award.
I understand. Was there any terms and condition?
It is on page number 12 of the petition. Although this is in vernacular language, we have annexed it through English translation, that is on page number 14.
The learned counsel has submitted that as per the recordings of the Lok Adalat Kama, the entire amounts in settlement of the claims were required to be paid within 60 days from the date of settlement. Full stop. Issue notice, returnable 4 weeks. Petitioner to take steps for service of notice within a period of 5 working days from today. List after 4 weeks, along with service report.
Deeply obliged.
Item number 8.
Lordship, steps was taken upon respondent number 5 by way of Dusty. We have taken steps upon respondent number 5 by way of Dusty on 4/8/26, and affidavit was filed.
Yes, anybody appears for 5 and 6?
I'm for respondent number 6 and 7, Lordship.
You are appearing for 6.
6 and 7.
6 and
7.
how many respondents are there?
7 respondents.
7 respondents. Yes.
Okay, who represents one? Madam,
Your Lordship, I'm appearing for respondent number
Two you
1,
would
2,
represent.
3, and 4, Your Lordship.
1, 2, 3, and 4.
Yes, Your Lordship. And the fifth is the private respondent.
You are representing 6 and 7, madam?
Yes, Lordship.
5, none represents as of now.
No.
Anybody appeared earlier for respondent number 5? No.
Not yet, my lord.
TCR has been received. Heard Mr. So-and-so learned counsel appearing for the petitioner, also for the appellants. Also heard Miss So-and-so for the respondent number 1, 2, and 3, and Miss So-and-so for the respondent
Your
number
Lordship, 1, 2, 3, and 4.
1, 2, 3, and 4, and Miss So-and-so for the respondent number 6 and 7. Full stop. The petitioner has filed an affidavit showing the service of notice by Dusty on the respondent number 5. Full stop. However, none appears. No, this service of notice on the respondent number 5. When was it served, sir?
3rd of 4th of this month. I believe it's 4th of this month.
Where do I find it? The Dusty service was effected on 4/8/2026. Full stop. We have seen the affidavit regarding the service of notice by Dusty on the respondent number 5. None appears for the respondent number 5 today. Full stop. Service on the respondent number 5 is deemed to be complete. Full stop. Since all the respondents have been served, comma, list this case again on
Eight. 8 September, Your Lordship.
8th of September 2026. Full stop. The TCR has been received. Yes.
Much obliged, Your Lordship.
Obliged.
The TCR has been received. You write one line ahead before the date fixing.
Item number 10.
to press this matter anymore. my lord.
Sorry? No, you were in.
I don't wish to
item
press it, my lord. Yesterday I have come to know that.
No, you
No,
were.
no,
You were
11
in
is
item
also me.
11 or
Somehow
12.
my name is not being reflected. I'm in 11 as well as 12. 12 has already been taken adjournment. 11th, I am not pressing it. Yesterday, I have come to know that there is a bail application pending in the lower court. I don't know how things are happening. So I will not make any submission on merit. Once it has come to my knowledge, I'll not pursue.
Yes, madam. Can you verify that?
Yes, my lord, I have verified, my
Oh,
lord.
you
It
have
is there
verified.
because
So we'll dismiss
I
this
have
petition.
verified. My lord, I am withdrawing it, my lord.
Heard Mr.
Whatever your lordship passes, I am obliged, my lord. Whatever your lordship passes, I am obliged.
Heard Mr. M. Biswas, learned counsel, appearing for the petitioner through VC. Ms. Mariel Khyamti is present, learned APP is present on behalf of the state, full stop. The learned counsel, Mr. Biswas, has fairly submitted to the court that he would not like to press the present bill application since he has been recently informed that there is another bill petition pending in the trial court, full stop. In view of the submissions made, this court, this present bail application is dismissed.
Conditions kita দেখাইছিল আমি এইখন conditions বিলাক ক'ত আছে
Yes, next.
Your lordship.
Item 13.
May it please your lordship,
Yes, sir.
this is a writ petition filed by a proprietor firm.
Huh.
The basic allegation is that he has executed a public works department road construction work, which he got the work order in 2019. He has duly completed the same in March 2026. The total admitted amount is about 32 crores, and he has received already 30 crores. The remaining amount, there are two components, because the work was of 36 crores value. He received 30 crores and additional 1.3 crores. They have processed the bill also, which lordship will find page 117.
Yes.
117, na? 177.
177.
Lordship will see page 175. It starts. Running account bill, and lordship will kindly come to page 177. Your total value of work done up to date, that is in group A, 32 crores 37 lakhs 06,505. Deduct value of works done shown in previous bill, 30 lakhs. Net value of work done since previous bill is 1 crores 81 lakhs 37,455.
Okay.
So this is the value which is still outstanding. That is number one. And his total work, the work order, if lordship is pleased to see, the work order is at page 24. The total value is 35 crores 07 lakhs 21,003. That is for the 20 kilometer stretch from Chukhe to Siasi. So he has completed, and there was a slight deviation also. For that also he has to execute some additional work. That approval is at page 147.
Page 147.
This was on 1st September 2025. Subject construction of Chakhe to Siasi Road under CRF Group A. With reference to above, as this is within the sanctioning power of the undersigned by SOP for CPWD Manual 2024, Annexer so-and-so. 3B for deviation of the construction of Chakhe to Siasi Road under CRPF amounting to 1 crore 52 lakhs 63,500 only, and I do hereby convey the approval for the deviation for further necessary action.
Yes.
So now 35 crores, the original work order plus this one, so it amounts to about 36 crores, and completion certificate lordship will find at page 150. 151 also. 150, Lordship, is a percentage of work completed, last column, 100%.
100%.
And next page is the chief engineer certificate. With reference to above, I have the honor to inform you that the completion report along with drawings, salient information and photographs of the work construction of road from Chake to CRC 20 kilometers under CRPF Group A and Group B is hereby approved. So this is the completion certificate. Page 150 and 152 are the annexures of 151.
Okay.
So now my humble submission is that, Lordship, this is a proprietary firm and the person is severely ill. He is suffering very serious illness. So my submission is that, Lordship may be pleased to issue notice. Let them respond also, because the admitted amounts are very clear.
Yes.
They have processed up to 32 crores, but remaining 4 crores also they have not processed till now. There is a provision under the terms and conditions of the tender, page 98.
98.
In 98. 42.1, the contractor shall submit to the engineer monthly statement of the estimated value of the work completed jointly measured by the engineer's authorized representative, less the cumulative bill certified previously. So they maintain a measurement book. 42.2, the engineer shall check the contractor's monthly statement within 14 days and certify the amount to be paid to the contractor after taking into account any credit or debt for the month in question in respect of the materials of the work in the relevant amount and under conditions set forth in the subclause 51.3. The value of the work executed shall be determined by the engineer. The value of the work executed shall comprise the value of quantities of the items of the bill of quantities completed. The value of the work executed shall include valuation of variations and compensation. The engineer shall exclude any item paid in a previous bill or reduce the proportion of any item previously paid in any bill in the light of the latter. And payments, 43.1, payment shall be adjusted for deduction for advance payment, retention, other recoveries in terms of the contract, and taxes at source as applicable under the law. The engineer shall pay the contractor the amount billed within 28 days from
28
the
days,
date of each hearing. So all those, therefore, a cause of action has arisen, and hence my prayer is very clear. Lordship will find my prayer. That one prayer is that the first prayer, page 16. The amount of 1 crores 81 lakhs 37,455, which is already processed and which is outstanding according to their own admission, this may be paid immediately. And also I am praying for a mandamus for preparing and releasing the bill of the remaining 4 crores 21 lakhs 11,142.
Okay.
So this is my case in a nutshell. So at this stage, Lordship may be pleased to issue notice. Let them respond also. I have given all sufficient materials to show it is covered by the Kamsem Ali's case also, when the chief engineer provides, and there is no dispute regarding completion of the work. They have already paid 30 crores out of 31.80 lakhs, and remaining they have not processed.
Okay.
So they should do it as soon as possible, because under the contract also within 28 days I am supposed to receive the amount, and the amount is already lying with them. There is no shortage of fund.
Okay. Heard Mr. D. Sogyal, Learned Counsel, Learned Senior Counsel, appearing, Learned Senior Counsel, assisted by Mr. B. Gogoi
P. Gogoi and P. Borua.
and P. Burwa, Learned Counsel, appearing for the petitioner. This petition has been filed under Article 226 of the Constitution of India for issuance of a writ in the nature of mandamus or any other appropriate writ requiring the respondent authorities to release the outstanding bill amount of rupees, you take from page 16, huh? Rupees so and so, payable to the petitioner firm for completion of contractual work of so and so, comma, and for directions to the respondent authorities to prepare formal bills and release the balance amount of rupees 4 crores odd for completion of the construction of the contractual work, namely so and so. Stop. The Learned Senior Counsel has drawn attention of this court to the letter of acceptance dated 24th of June 2019 for construction of road from Chaiki to CRC under CRF Group A. The learned senior counsel has also drawn the attention of this court to the terms and conditions of contract by which the payment of the bills submitted by the contractor was required to be paid within 28 days of the date of each of the RA bills. The learned senior counsel has drawn attention of the court to the work completion certificate dated date of commencement, name of work agreement, definition one.
Page 152, the date will be there.
Dated
In one, there is no date because one is the annexer.
dated 20th of April 2026, issued by the Chief Engineer PWD, Highway to the Superintending Engineer. Full stop. He has also referred to the other works, work completion certificate issued on the basis of the aforesaid certificate. Full stop. The learned senior counsel has submitted that the running bill account, which is annexed as Annexure L to the writ petition, shows that the total value of work done up to date was 32 crores 37 lakhs 6,000 and odd, while the value of works done shown on the previous bill was to the amount of rupees 30 crores 55 lakhs 69,000 odd. Full stop. He accordingly submits that the admitted amount of the aforesaid bill is rupees 1 crore 81 lakhs 37,455. Full stop. The senior counsel has submitted that the matter will be covered by the decision of the court in Tamsher Ali in the event the respondents do not dispute the the amount claimed to be admitted by the petitioner. Full stop. Issue notice. You are appearing for, madam?
Now, all the respondents, madam. 1 to
Miss
6.
Miss Linda L. Fombel appears for all the respondents. Full stop. Extra copies of the writ petition to the learned counsel appearing for the respondents. Full stop. List the matter again on. When can you have your instructions?
Regarding the interim prayer.
There is a medical certificate saying that the petitioner is undergoing a very bad phase. So
Let it come up after a week.
after a week.
I have talked to the department regarding the interim. They are not very sure. Just this morning I had called up. They said the funds might be exhausted at the moment. So
The absence of a fund would not be a very good ground for you to not pay for works done. We'll have it on 1st of September, sir. Is it convenient?
Lordship, no difficulty.
third,
3rd of September.
3rd of September.
List again on the 3rd of September 2026, allowing the learned counsel for the respondents to have instructions in the matter. Full stop. Since the matter relates to payment of bills on admitted amounts, allegedly on admitted amounts, an attempt would be made to dispose of the writ petition on the next date of listing.
Next item also, Lordship, same work. There were two groups. One group A, Lordship had just dealt with.
Yes.
The other one is Group B, and the figures, Lordship, will find at page 16 in the prayer portion.
Just
Identical documents are there.
the prayer in the second petition you will take from page 16 onwards. And
Outstanding there is 32 lakhs here. 32 lakhs
The-
78,277.
the work order you would find at page 24. Then page 24. Then the work completion certificate would be at which page, sir?
Yes, it is 150, 153.
156, 152 onwards.
152 onwards, same, identical.
153 again. Page number 153.
Date is also same.
20 April 2026. And the bill would be at page 165. Huh? The running account bill, so page 165. And the amount there would be at page 167. That other, in the other matter I said 30 crores and 32 crores. No? Here it is 32,78,277. Huh? Remains unpaid. Okay. The rest of it will remain the same. Acha, in the earlier order you take down one part also. Formal steps are dispensed with. Before you write that, extra copies on the counsel for the respondent. Is it formal
One
steps are
further
dispensed?
line, Lordship, I am praying
Yes.
that pendency of the case may not be a bar for them to release the
Huh.
payment.
It is made clear that the pendency of the repetition shall not be a bar for the respondents to release the payments to the petitioner. Yes, sir.
Highly obliged, deeply
Thank
obliged.
you.
Item number 15.
15.
May I please, Your Honor?
Yes.
This,
We said we'll consider the interim order today.
yes, sir.
Huh?
Yes,
We
Lordship.
were
as
about to
per-
ask you in the morning.
Yes, yes, Lordship.
Yes, tell us.
Yes, Lordship, as per this, my bank account was attached.
You just tell us, sir. Mr. Johnny, you tell us. How do you say that the order will survive after 1 year?
Lordship,
You are keeping a man hungry.
Lordship, we have no objection for the restoration of the bank account belonging to the petitioner. May I take Lordship to page 98 of my affidavit filed by the
90,
respondent number 2.
Page 90.
98.
Just a minute. In the earlier case, no? In the earlier case, the first one, item number 13. The tag is broken, so all the papers are. Don't know new tag. Huh?
Page 98.
Page 98 of your affidavit.
Or affidavit of the respondent number 2.
This is by respondent number 2. Unfortunately, the pages are still 1, 2, 3, 4, 5. Tell us the internal page number.
It's in
What would be the internal page number?
my page 98, 98.
What does it say?
Here it
Para
says
number?
that, so it's in Annex 22. page
Annexure 22.
22.
Okay. 32, 23, 22. Yes. Okay, 98, huh?
92. This is the letter issued by the Commissioner, CGST, Lordship, and restoration of the provisionally attached bank account under Section 83 of the CGST Act. So in the last paragraph, since the said account is no longer liable for attachment in terms of Section 80, so it may now be restored to the person concerned, Lordship.
Yes,
That
anything
letter
more?
was issued on April, Lordship.
Should we pass an interim order, or can you go with this document to the bank and say that let me operate the account?
Lordship, as per 83, Lordship.
Huh?
As per Section 83 of the
Ah.
CGST, Lordship.
Huh.
May I go through, Lordship? This,
Please.
is provisional attachments to protect revenue in certain cases.
No, sir.
Where during the pendency of any proceedings under Section 62, Section 63, Section 64, 67, and 73, and 74. In our case, it is invoked Section 74, Lordship. Section 74, the commissioner of the, if the commissioner is of the opinion that for the purpose of protecting the interests of the government revenue, it is necessary to do so, he may, by order in writing, such provisionally any property, including bank account belonging to the taxable person, is in such a manner as may be prescribed. Para 2. Every such provisional attachment shall cease to have effect
Mr. Rukum.
after the expiry of
Mr. Rukum, have you seen page 98 of the affidavit in opposition?
I have seen, Lordship, but
Does it not solve your purpose? For the time being, the interim. Do you have that page 98?
yes, Lordship.
Please read it.
Restoration of provisionally attached bank account under Section 83, Lordship. Please so, since the
refer
said
to the
account is no
attachment.
longer liable to be attached in terms of the Section 83 GST, it may be now be restored to the person concerned.
I think this is
So
what
your
they are.
interim prayer is Answered.
Answered, Lordship. It's allowed.
Your bank account is now operable from 342026.
But Lordship, I am informed that the petitioner, he could not,
I can suggest you one thing. Ask the petitioner to give your assisting counsel a check. Let that be deposited.
no Lordship, if some observation is made,
No, we'll make an observation that already the respondents have said that the bank account is no longer required to be attached.
yes,
And
that would-
therefore now the interim prayer would not require any further consideration.
Lordship, yes.
Since
that's
the
true.
state bank, since the concerned bank has been informed by the respondents, you will be at liberty to operate the account to your convenience.
Yes, Lordship. Very true, Lordship.
And the other part of the this repetition
Lordship, in this
regarding the penalty and everything that we will decide.
that will be decided. And Lordship, we have a strong objection regarding maintainability of this writ petition.
Huh.
Because there is a statutory provision under 112 of the CGST Act. There is an alternate remedy.
It is before the tribunal,
Yes, yes.
appellate
Lordship.
tribunal.
Yes.
Yes.
the Lordship,
112 of the CGST.
Lordship, our contention is that section 74(1) it is strictly confined in three things, Lordship. One is fraud, and one is
We are not on that. What he is trying to say is there is already a provision in law where you can file an appeal against the penalty, get your decisions made there, failing which you would have the other opportunity of approaching this court. But if there is a provision of appeal within the act itself, should we entertain this writ petition? We were anxious because your bank account was freezed and you were not allowed to transact. Now that problem is solved.
yes, Lordship.
Now the question of law, when there is an appellate forum, why should we entertain a writ petition?
Yes, Lordship.
Unless you are saying that it was a violation of principles of natural justice, they have not heard you at all, they have acted beyond their powers. That is another issue. But here you are saying that I did not commit fraud.
Yes.
From the evidence available, it is not fraud. From the evidence available, it is I was not at any fault. They have made a mistake in appreciating the evidence. Supreme Court says if it is appreciation of evidence, please do not entertain a writ petition. Please ask him to go to the appellate forum. So we can only request you to go to the appellate forum.
Lordship, let me take instruction
We
from
don't
my,
want to give you directions to go to the appellate forum. We want you to take the opportunity and go to the appellate forum.
Yes.
Because now your bank account is not under freeze. Whatever penalty has to be paid, you have to pay it out of your pocket, or they will go for some other modes of execution. If you can get a stay in the appellate forum, we'll say that this was the wrong forum and
Lordship, yes.
perhaps any condonation of delay, if there is any
Very
delay
true,
in
Lordship.
preferring the appeal, the appellate forum would keep in view the fact that you had approached the High Court, you had approached a wrong forum.
yes, Lordship, let me take instruction from my client, Lordship.
Huh?
Okay.
Instruction
Let me give
line
some
is
time.
required.
Let me give some time to
It may
take
not be
instruction
necessary
from my
to
client.
get the
Lordship.
instruction from the client because the law is very clear, Lordship. Since there is a statutory alternate remedy which is prescribed by law, Lordship, and there are other several cases prior to this also, and they have approached this honorable court, and this honorable court had
Do you have
Ladies-
any of those orders?
that orders, Lordship. It's not with me today because today I thought that we are concerned about only the interim order, that interim.
We
Because
were
the law
taught-
is very clear, Lordship.
we were taught to be prepared for a disposal every day.
And I have clearly stated in my admission also, because very clear, in 112 of the CGST Act, and there is a late
Okay, we'll
process.
give him one opportunity to have a discussion with his client. Otherwise, we can close it today. There is no difficulty.
Yes,
Just
yes.
ask for it. We'll give him a day.
Okay.
Huh? Heard Mr. A. Rokum, learned counsel appearing for the petitioner. Also heard Mr. Your full name, I'm still struggling with the names most of the time. Johnny L.
Tochong.
Tochang.
Tochong.
Is it? Okay, Tochang. for the respondent
Number 2 and 3, Lordship.
number 2 and 3.
My name is not reflected in the cause list, Lordship. That the
necessarily.
registry may be directed to
will be
reflect
that.
my name.
Anybody else you are paying for? Madam appears for respondent number 1 and 4, 5 and 6. Full stop. That today was fixed for consideration of the interim relief paid for by the petitioner. Full stop. In response to the submissions made by Mr. A. Rokum, learned counsel for the petitioner, Mr. Johnny L. Tochang, the learned counsel appearing for the CGST, has submitted that as per the letter dated 34/2026 issued by the Commissioner, CGST, ISOL to the branch manager of the State Bank of India, Daurpui, ISOL, Mizoram. The account, savings account number 10276792202 within bracket IFSC number SBIN 0004809 held by the petitioner in the State Bank of India was no longer liable for attachment in terms of section 83 of the CGST Act 2017, and therefore a request had been made that the account may be restored to the person concerned. Mr. A. Rokum, learned counsel for the petitioner, has submitted that he does not have instructions from the petitioner that the said bank account in issue has been made operable. He prays for a short accommodation to have his instructions on the matter. Having regard to the communication dated 34/2026 issued by the Commissioner, CGST, ISOL, informing that the account of the petitioner detailed above was no longer liable for attachment, this court is of the view that the interim relief prayed for by the petitioner has been answered. Accordingly, it is accordingly, the petitioner would now be entitled to operate the aforesaid account to her convenience, since it is no longer under attachment.
Yes.
Mr. Johnny L. Tochang, learned counsel appearing for the CGST, has submitted that this present writ petition is not maintainable in view of the provisions of section 119 of 112 of the CGST Act, wherein provisions have been made for consideration of appeals against orders passed by the
Lordship.
orders of penalty passed by the appropriate authority.
Lordship.
Full stop. The learned counsel has submitted that when there is an equally efficacious alternative remedy available to the petitioner, this petition may not require any further consideration of this court. In the event, the petitioner is allowed to approach the appellate authority with his grievances in accordance with law. Full stop. Mr. Rokum, learned counsel for the petitioner, has sought for an accommodation to have his instructions on this issue also. Full stop. Accordingly, list the matter again on 21st of September 2026, on which date the learned counsel for the petitioner shall inform the court whether the bank account has been made operable and also whether the writ petition is maintainable in view of the provisions of the CGST Act.
CBS.
Most of us.
Anyone for hearing?
No part to hearing. Okay. Keep this. Facial recording. Thank you.